All right, you guys. It's about 6:31 on my clock, so let's get this show on the road. I'm really happy to see a lot of you guys here today. I've also typed some text in the chat box so that you guys can pull that up, and please feel free to add any comments or questions in there as we go through this. All right. This is Successor Trustee School Part 2, the sequel. So let's just do some housekeeping items right here. We're doing this over Zoom, and we'll be recording the presentation so you guys can see it later again if you want. Please feel free to submit any questions you'd like over the chat function so that I can go through and try to answer some of the questions. We'll also be muting the microphones until we get to the question and answer section. And I'm hoping to have a lot of interaction and questions from you guys, because that's the part that really makes it fun for me, to help you guys out. Without further ado, let's get started. Just a little introduction for myself if you haven't met me. My name's Chris Hall, last name H.A. like I'm a funny guy. My specialty is I'm a board certified estate planning attorney. Went to Texas Tech School of Law, business school at UT Austin, and I've got a certified financial planning designation so I can help you guys out, not only with law, but your investments too. A little note about our law firm here. Here's the contact information for our law firm right here. Our specialty is doing estate planning for our clients and asset protection. And so if you ever need to get a hold of us, especially if you've got a personalized question that you just want to give to us directly, here's our contact information on this slide here. And without further ado, let's get going. I want to let you guys know in on a little secret. We have a successor trustee manual in the books. So once we've got that ready, we'll let you know so you can order it. And the nice thing about that manual is it's got everything in part 1 and part 2. And you can give it to your successor trustee so that they've got a reference manual to answer any questions they may have. So, big picture. We did part 1 of the successor trustee manual school. What is a trust? Why set it up? How to set it up? How to select a trustee? So that's the part we covered in part 1. Let's see in part 2 though. I originally thought, oh, let's just finish up part 1, but I decided to remake this presentation, make it new. So here's kind of the roadmap for our presentation tonight. We're gonna start with a case study. Mama Texas. She's got a revocable living trust, and then she passes away. So Bevo, her successor trustee, has to take over. What are the things that he needs to do? How does he locate Mama's assets? How does he get custody of her assets? How does he pay her expenses and make distributions? That's what we'll be covering tonight. Just want to give you an idea of the stuff that we won't be covering this presentation, but we might be doing in other presentations. We'll be doing we won't be covering federal estate tax issues or entities like LLCs or LLPs, or the probate process. Topics for another presentation. So let's recap. Those of y'all who were in the first part already know the answers to these. What is a trust? A trust is a method of holding property with 3 people. The grantor is the person who contributes property to the trust. The trustee is the person who holds the trust property. And the beneficiary is the person who's got the best job. The beneficiary is the person who receives the trust assets from the trustee according to the instructions in the trust. So here is our first example with some questions. Anakin says to his buddy Ben, Ben, please hold my lightsaber from my son Luke until he is age 18. Let's take a look at this. There's Anakin, Ben, and Luke. What is Anakin's role in the trust? Hannah, can you turn on everyone's mic so I can hear them? You can also type answers in chat. Okay, in this case, Anakin is the grantor. He's the one contributing property to the trust. Ben is the trustee because he's holding the property of the trust. And Luke is the beneficiary because he's the one who's ultimately going to receive the property of the trust. So let's go to the next item. The other issue that we have with making a trust is that the benefit of the trust is that it avoids the probate process. So you might remember from the last presentation, when you hold assets in your sole name at death, if you are holding assets in your sole name at death, those assets typically get frozen at death. And you have to get a judge's signature to get access to that asset, whether it's a piece of real estate or it's a checking account. In contrast, if your assets are properly put into the name of your trust before death, the assets are not frozen. Typically, your successor trustee can show up and say, hey, I'm the successor trustee for this trust. I'm going to fill out some paperwork and show you that I'm the successor trustee. And then that person can get signing authority for your assets without going through the probate court process, without paying $4,000 for an attorney, without having to spend the time in the court process. So let's go through an example of that. Probate example number 1. Sue Ellen and JR buy a rental property together as husband and wife in their joint names. JR suddenly dies, very mysteriously. Can Sue Ellen sign for the rental property after JR's death? Yes or no, and why? What do you guys think? Any answers in the chat box? I've got one answer, maybe, depends on the contracts. Any other answers? In this case, this example is to show the benefit of having a trust. Because in our case, you'll see in the fact pattern, Sue Ellen and JR buy the rental property as husband and wife, not in the name of their trust. So if JR dies suddenly, then you've only got Sue Ellen. If Sue Ellen tries to sign for the rental property or sell it after JR is deceased, the title company would look at Sue Ellen and say, okay, I see your name on the property, you can sign for your part, but where's JR? And JR is deceased. So their answer is going to be, well, if JR is not here, I want to see a judge's signature saying that you have authority to sign for JR's half of the house, the rental property. So that's one of the big reasons why we like having a trust, to avoid this expense and time of going through the probate court process to get signing authority. So with that recap, let's go into our case study. Mama, Texas. Mama, Texas has a revocable living trust. Very standard revocable living trust. Some of you guys may have the same type of revocable trust where it says during Mama's lifetime, she has full control over the assets of her trust. She can revoke her trust, she can amend it, and she can do whatever she wants with the trust assets because she runs her trust. Her trust is written so that when she dies, her trust is divided equally between her 3 sons, Bevo, Reveille, and Master Rider, and her successor trustee is Bevo. Let's see what her assets are. Mama's assets are a house in Texas, She's got a checking and savings account, and she's got a life insurance policy. She used to have more assets, but she got mixed up with this guy, J.R. Ewing, and, well, she didn't come out on the winning end of that divorce. Mama's got the normal set of debts you might expect. She's got a mortgage on her house, and she's got a credit card. Her children get along well, except there's a little thorn in the side. Masked Rider has creditor problems, and he might be getting a divorce soon. So this leads us to one of the common features in a revocable living trust that we almost always put in our trust for our clients. So I'll show you that now. This is a bonus item. I wasn't sure I was going to put it in, but I really love this fact pattern. So this helps you see one of the features in a lot of trusts. In the normal case, when you've got a good attorney drafting your trust, it'll typically say, I don't like to leave assets to my beneficiaries outright. I like to leave assets to them in an asset protection trust. So that way, their inheritance is protected from divorce and from creditors, because their inheritance is held in a trust entity, so that when the divorce happens, the divorcing spouse can't reach into the trust and yank those assets out. Same thing with the inherited cash. But let's give a fact pattern here. Assume that Mama's trust gives all her assets to her kids outright. And Masked Rider gets his inheritance outright, not in an asset protection trust. Later, he divorces his wife, and she wants half of the inheritance. She says it's community property. Can the wife seize the inheritance? Why or why not? What do you guys think? Connie, I see a big smile on your face. I'm going to tease Connie because I know her really well. We love each other to death. Okay, make a mental note. Do you think that the divorcing spouse gets part of the inheritance? I see an answer in chat, ex-wife could take a portion of the inheritance. I see, Connie, I think that you're nodding your head. Oh, that's a nod. That's a nod. You guys, the answer is yes, probably. The argument that the divorcing spouse is going to make is that, hey, Masked Rider, you inherited these assets, and the general rule is that inherited assets are separate property, so they're not part of the divorce split. But her crafty argument is going to be they commingled. Your assets mixed with my assets. You didn't keep it separate. You didn't set up a separate trust that says these assets are my inherited assets. Nothing else is in there. So what she's going to do is say, hey, the default rule in Texas is that if you've got property of a husband and a wife, it defaults into community property. So she's going to try to seize those assets. So if you look at your revocable living trust and you see that it says, I leave my inheritance in a descendants trust or an asset protection trust, that's why. It's to make sure that your kids keep their inheritance and don't lose it to a divorcing spouse or creditors. Okay, forgive me, I love this fact pattern. I want you guys to know about this feature in your trusts. So, sad story, you guys. I love Mama Texas, but she passes away. She passes away. So Bevo is the successor trustee. He's got to step in and say, okay, I've got a trust document. It says to distribute the trust assets 3 ways. How do I do that? What are the steps that I take? So here's the roadmap right here. He's got to find Mama's assets. He's got to get authority to control them, to sign for them. He wants to pay her bills, and then he wants to start making distributions to beneficiaries. But remember, we got to do this stuff up front first. You can't distribute assets unless you know where they are. So let's deal with that one first. Okay, you guys, you're Bevo. Mama Texas just passed away. How do you find her assets? How do you know what she owns? Ideally, Mama Texas would have left a breadcrumb trail. She might have left a balance sheet, business cards. She might have left monthly statements for you to find, but you might not have those things. So let's deal with the first one, real estate. How do we find real estate? Mama Texas passes away. You suspect she owns real estate, maybe oil and gas interests. How do you find those assets? Where would you look? Any answers from the audience? Here's where I would look. Typically, what I advise my clients to do is if you know where mom has lived before, check the county tax records where she lived. For example, in Travis County, that's traviscad.org. Type in the variations of mom's name that you know and try to see if you've come up with anything. If you've got her income tax return, the Schedule A like alpha, shows where she paid real estate taxes. So that might give you a hint. Schedule E like echo lists where she gets royalties and rental property income from. That's typically where you will see oil and gas interests show up on Schedule E. If you have the 1099 miscellaneous statements that come with the tax return, that often gives you hints on who's paying money to mom for oil and gas interest. So a lot of this is digging through the mail, digging through tax statements, and trying to see what you can find for mom. The next one, how do I locate mom's financial accounts? And this is oftentimes where you find a lot of the value of the assets outside of real estate, right? A lot of people have a lot of their investment, a lot of their net worth inside the checking and savings accounts and their investment accounts, whether it's normal investments or retirement accounts. How would you find these assets? I'm looking at the chat. Connie, I love your comment. Hire Chris to look for them. You know, I'm quite partial to that answer because I get legal fees for it, but I'm going to give you the free answers because I love you guys. Adrian, I see your answer, public records. Exactly. That is the right answer for real estate because real estate is typically public record. The county tax assessor wants your money. Okay, so where do I find financial accounts? Check the mail, check the email. You're really hoping you can find monthly statements. That's the best source because the monthly statement tells you how much is in the account and hopefully who you can call to get access to the account and phone numbers and addresses. If you've got the tax return, here's what you look on the tax return. Schedule B like Bravo lists the taxable interest and taxable dividends that are paid. You see a Schedule B over here on the left on the screen. If you've got the supporting IRS forms, the 1099 forms, those are really good too because they often have account numbers on them. And finally, hopefully, if you have mom's contact information list, you can call her banker or her financial advisor. And hopefully they'll answer the phone. You can get some information out of them. Okay, here's the next one. And I know this is not the happy one to look for. I apologize, you guys. We gotta find mom's debts and find her expenses because as trustee, we need to pay her valid debts and expenses. How do we find these? Wait for the bills to come in. Yes, that is a very good answer. In effect, that's basically it. Basically, we're looking for monthly debt statements. The nice thing here is that creditors are very motivated to get paid, so they tend to be very timely about sending you monthly statements. So typically, as long as you get mail forwarding done, you're going to get these statements. The things about real estate is that you really want to find the mortgage statement. You really want to get a hold of that and keep paying that so it doesn't get foreclosed on. Insurance, utilities, lawn care, HOA fees, those are things that typically go with real estate. You want to get those things paid too. And as a last-ditch effort, this is your gold standard right here. See this link right here, annualcreditreport.com? That's set up by the federal government. So if you go on there, you can request a credit report from Experian, Equifax, and TransUnion, and the credit report will give you a list of all the accounts they know about in mom's name and whether the account is still open or closed. So that way you can start addressing those accounts. All right, you guys. How do you find mom's life insurance? How do you find mom's life insurance? Typically, it's very similar to what we've been seeing before. You're looking for bank and insurance statements. But the special thing for these is that on some policies, mom will be continuing to pay premium payments, right? Monthly premium payments or every 6 months. So you can find a breadcrumb trail that she's been paying for insurance in the bank statements. However, in some cases, mom might have life insurance where she's fully paid for it already, and she's not going to make any more monthly payments on it. So typically, you're looking for insurance statements that say, oh, here's the insurer, here's the value of the life insurance policy, here's who it pays to. You're going to try to see if she's got an insurance agent or a financial advisor, because if they know about it, they can tell you about it. For a lot of our public employees, federal employees, or people who work for big Fortune 500 companies, they might have life insurance through their employer. So you might want to call the HR department of the employer too. So, moving on, we have just helped Vivo through the process of finding the assets. And I'll tell you guys, that's a big part of it. If you know where the assets are, you're halfway home. We kind of went through it really quickly, but if you find the assets, you're almost there. So this next part, getting custody of mom's assets, is typically not that hard once you know where the assets are. Now, for those of you who are not the successor trustees, but you're training a successor trustee, the lesson from this is that leave a breadcrumb trail for your successor trustee so they can find your assets when you pass away. How do I get custody of mom's real estate once I've found it? Remember, you're in the shoes of Bevo, right? You're the successor trustee. In our case, mom's house was deeded into her trust before she died. She did a good job of that. That's exactly what you want, right? You want the house in the trust. Now, Bevo is the successor trustee. What does he need to do to sell the house as the successor trustee?
Put it up for listing.
Say that again, I didn't hear you. Any answers in chat?
What does he have to do, Dave? The house was deeded to Mama, trust before her death. Very good. What does Bevo? He was the guy. What does he need to do to sell the house?
Yeah. I'll tell you. Yes, Connie, you're exactly right. So you get a real estate broker. So what'll happen is you get a realtor.
Put it on market.
The realtor exactly, right. You put it on the market, right? And the nice thing here is because we did the homework before Mama died, it's in the name of her trust. When a title company gets involved and checks the deed records, they'll say, hey,
Good real estate broker.
this house
Probate card.
is in the name of the trust. So that means that all I need to do is verify that Bevo is the successor trustee. Typically, the title company will say, can you show us a copy of the trust so we can see the section that says, after Mama dies, Bevo, you're the successor trustee. After they see that, they'll say, looks good to us. Bevo, you do not have to go to the probate court to sell the house because the house was already in the trust. You're the backup trustee, so you're the one who can sign for it now. Adrian, thank you for your answer. I really appreciate that because we're gonna test the other scenario. Here's the other scenario. What if the house was not, I repeat, not deeded into the trust before Mama died? So it's in Mama's name when she dies.
Then you have to go to probate court. You have to go to probate court.
You nailed it. Exactly. Did everybody hear that? That's exactly right. If the house was not in the trust before Mama died,
Volume.
then that just means the title company is going to say, hey, this house is in Mama's trust, and Mama's individual name, and she's not here to sign. So I want to see a judge's signature before I let anybody sign for this, because we're on the hook for this house if we don't have the right signer. Oh, Adrian, I see your comment. Yeah, you were answering the question at the bottom. That's great. Okay, next slide, you guys. How do we get custody of financial accounts? Before Mama's death, her bank accounts they were moved into her trust before she died. So they're in the name of her trust right now, and then she passed away. How will Bevo get signing authority over those trust accounts? I'm happy to tell you that this is a lot easier than finding the accounts. In this case, what you do is you typically hire an attorney to help you with this, and what they'll do is they'll prepare, we call it a certificate of trust. Other estate planning attorneys might call it something different. And you give that certificate of trust to the bank, and then it's basically a summary of the trust. And it says, here's the name of the trust, here's the date of the trust. The trust was originally made by Mama, but the backup trustee is Bevo. And then it will have excerpts from the trust. They will look over that and say, oh, yeah, looks good to me. So if you verify your identity that you're a Bevo, typically with the driver's license.
7:15 if you want.
If you fill out some paperwork at the bank.
I said I can eat at 7:15 if you want. Or 7.
Then you will be able to get signing authority over the account.
Over.
Next question. How do you get custody of life insurance? In our case, Mom has a life insurance policy and the beneficiary designation says, I leave my life insurance policy to Mama's trust. What does Bevo need to do to get a hold of the life insurance death benefit? In this case, what Bevo would do is that now that he's located the life insurance company, he's going to send them a death certificate. He's going to get them on the phone and say, I'd like to report a death, and I'd like to give you the death certificate. With the death certificate, then they'll say, okay, this policy is now ready to pay, and they'll cut a check to mama's trust, because that's what the beneficiary designation says to do. So when you've got a life insurance policy and you find it, you want to submit the death certificate of mama to the life insurance company so they know it's time to start making payments of the death benefit. Okay. So I got a question in the chat. Going back to life insurance, it says, wait a second, Chris, hold on. You assumed that the life insurance policy has a beneficiary designation on it. What if the life insurance policy has no beneficiary on there? No beneficiary. I know you can't see me, but that's a wag of the finger to the camera right there. That's a no. If the life insurance policy has no beneficiary on it, you've got a nasty situation here, because what it's going to do is it's going to say it needs to pay to mama's estate. It needs to pay to mama's estate. Typically what that means, and you might not like this answer, but this is the result, is they're going to cut a check that says to the estate of Mama Texas. And you know what you have to do to cash a check that says to the estate of Mama Texas? You've got to go through the court process to become executor for Mama's estate so that you have authority to open up an estate checking account that will receive the check. Most banks, at least every bank that I know about, will say if you give them a check that says estate of Mama Texas, their answer is going to be, prove to me that you are the legally appointed executor for Mama's estate. And that requires court paperwork. So that's a great question. If you've got life insurance policies, make sure the beneficiary designations say what you want them to say and are not blank. Otherwise, even if all your other assets are in the name of your trust, if that asset is payable to your estate, you might be paying Chris Hall $4,000 to go through a probate court process to get access to one check. And that doesn't really help you that much. I mean, it helps me, but that's no fun for you. So the next item here is, let's recap where we've gotten so far. So far, we've located Mama's trust assets. That was a lot of the work, going through the paperwork and finding her accounts and her real estate. And now we also have signing authority for her accounts and her real estate. We've made it so that we can control her assets. But before we can start making distributions to beneficiaries, you know, Texas says we got to pay the creditors, the valid creditors. So the question kind of becomes, what expenses do we need to pay? And if I'm Bevo, I'm the successor trustee, am I liable for mom's expenses now that I'm the trustee? That's a pretty common question. It's a pretty important one too. So let's go and take a look at that. Excuse me, guys. So which expenses should Bevo pay? Now you've got regular expenses like the mortgage, the insurance, HOA, and utilities. Typically, you want to pay those because you don't want the house to get foreclosed on by the mortgage company. However, sometimes you get debts in your Bevo and you say, I don't recognize that debt. It's not a familiar debt to me. What if Bevo gets a debt collector letter? What if Bevo gets something that says, Mama Texas owes me money, but there's no supporting documentation? Should Bevo pay that bill? Why or why not? What do you guys think? Any brave answers in the chat? I've got two answers. Now, without evidence that it's a real debt, is no, it could be a scam. I love both of you guys. That is exactly what I would say. That is precisely what I would say. Bevo has a duty to pay valid debts. Valid debts. So typically what I say here, and I tell you this because a lot of my clients, I typically represent trustees and executors, they get a lot of these letters. They just get these letters that come in the mail and it just says, I'm a debt collector. Mama Texas owes me $5,000. Send the check to my address. Here you go. And they do not include monthly statements. They do not include proof. As far as I'm concerned, if you can't prove to me that this is a real debt, Bevo, don't pay it. So Bevo goes, okay, am I liable for Mama's debts? Ginger, I see your question. We're going to get to that. That's perfect. Here's the general rule for Bevo, because, you know, being Bevo can be a little scary as a successor trustee. You step into this job, you worked a few weeks to find where the assets are, and then you discover there's a big mortgage. Fortunately, you can pay it, but there might be these big credit card bills or big medical debts, right? Like Ginger pointed out in the chat. So let's go with the general rule. And then, of course, I'm an attorney, so there's always exceptions. So I'm going to walk you through the exceptions. I'm going to try to show you the traps. The general rule is that Bevo is not liable for debts that he did not incur. For example, on the mortgage, his name's not on the mortgage. He's not responsible for that. The credit card, it only has Mama's name on it. It doesn't have Bevo's name on it. He's not liable for it. But, and this is the scary part, there's always a but different rules apply once you're the trustee. And the reason is that once you're the trustee, you have authority over the trust assets. So you have responsibility for managing the trust assets. So at that point, once Bevo puts on a second hat, now he's wearing the hat of trustee, right? It's not just him individually, he's wearing the hat of trustee. He controls the trust assets, so theoretically, a creditor could sue him for up to the value of the trust, up to the value of the trust assets at the time that he became trustee. So if the trust had $100,000 when he became trustee, he could be sued for up to $100,000 of trust assets. Now that's a little abstract. Let me give you an example. Assume Bevo says, you know what? Debts are for chumps. I don't pay debts. Debts are silly. I'm not going to pay any of the creditors, right? What I'm going to do is I'm going to take the assets and just distribute them. Well, a third. You know, I've got two brothers and me. Mom said equally to the three of us, I'm going to just cut checks. But you got to pay the piper. What happens with the following debts? Let's say Bevo doesn't pay the mortgage. What's going to happen now that he doesn't pay the mortgage? What do you guys think? Yes, I see two answers in the chat. Exactly. Foreclose, lose the house. Because remember, imagine you're the bank. You don't really care. This is going to sound heartless, but banks are heartless. They're going to say, hey, I'm owed monthly payments. And the mortgage says, if I don't get these monthly payments, eventually I can force you to sell the house to make myself whole. And they can definitely do that. And the nasty thing about that is that a bank is not incredibly motivated to get top dollar for the house. So they're going to say, hey, if there's a guy with cash and he's willing to pay and it's enough to cover my bill, they might go for that. And you only get what's left over for the kids. So, best advice to Bevo, pay the mortgage. Do not skimp on the mortgage. Typically, when you sell the house, they're going to force you to pay the mortgage, which is a good thing. Now, let's go to the next one. Ginger, I saw your question. Credit cards and medical bills. In our case, let's treat them as basically the same. They're unsecured debts in the sense that the creditor can't seize real estate when you don't pay those debts. So, what happens if Bevo says, I've got this big credit card debt, I got this big medical bill debt, but I don't feel like paying it. I'm just going to cut checks to me and my brothers and walk away. What can the creditors do about this, if anything? What do you guys think?
Yeah, sure.
They are going to sue Bevo. They're going to sue Bevo. Their position is going to be, hey, these trust assets are on the hook for this debt. And so Bevo, you're the signer for these assets. What you did was you should have paid us first because creditors should be paid first. And this was a valid debt. So we can sue you for up to the value of the trust assets when you became trustee. So in the example above, if he had $100,000 to begin with, and he distributed all of that $100,000, the creditor is not prevented from suing him because of the distribution. They'll just say, well, too bad. It's not our fault that you distributed the assets too early. We can still sue you to collect on our debt. And if they're very motivated, they can go after the beneficiaries too and track the assets. That is not a fun place to be. So typically what we're going to tell our successor trustee, Bevo, is to say, when you make distributions, leave a reserve. Leave a reserve for unknown expenses to make sure that if there are any debts that you didn't know about, you've got enough ammo in the tank, gas in the tank to cover those bills. And if you're not comfortable that you found all the valid bills, don't make distributions right away. Because you know who's going to get sued because of that? You are, Bevo, because you're the trustee. So that's the story with the debts. Whew, okay, shake it out, you guys. I know that was kind of scary. Let's get to something different. Let's cover what we've done so far. We did a great job of locating Mama's assets. We went through a lot of paperwork to find those assets. We got custody of those assets. We have signing authority of those assets. Bevo did the right thing. He did the right thing, and he paid the valid expenses and the debts of the trust. So assume that those debts are paid. So now let's deal with his duty of loyalty to the beneficiaries of the trust. Because remember, this isn't just his money. He's holding it for the benefit of him and his two other brothers. So we're going to cover these things in the next slides. He's got a duty of loyalty. He can't just spend the money any way he wants to. It's for the benefit of the beneficiaries. He has a duty to keep his other beneficiaries informed of what's going on, and we'll cover how to do that. And he has a duty to preserve the value of the assets and not waste them. So let's go through some examples of those. What if Bevo gambles away the trust assets in Las Vegas? Assume Bevo takes all the trust money to Vegas and loses it playing poker. What can the beneficiaries do? Has Bevo violated any duties to the beneficiaries? And can the beneficiaries sue Bevo? Why or why not? Let me know what you think. By the way, I love The Hangover. That's such a great movie. I've got one yes in the chat. Okay. I love your cheeky answers in chat. The beneficiaries can find Mike Tyson and his tiger to deal with the trustee. I got a yes. I got a good luck getting it back from Vegas. You guys are exactly right. So the beneficiaries are confronted with two problems. The trustee is definitely liable for being irresponsible, right? Because this money doesn't belong to him. It belongs to him and the other beneficiaries. It's not his money to gamble with in Vegas. So I think by any reasonable standard, he's gambled away the assets. He's wasted them. So it can definitely be sued. And you guys in chat made a great point. The beneficiaries are in a tough spot because the money's gone now, right? So they're going to have a tough time getting hold of the assets, but they can sue. Remember what they can do. The trustee is liable for the value of the trust assets at the day that he became trustee. So even if the trust assets are gone, they can try to sue him for his personal assets, up to $100,000 to replace the assets he misplaced. So Vivo, take care of these assets once you've got signing authority over them. Here's another hypothetical. Assume Bevo never responds to phone calls and questions and emails from the beneficiaries. He just never talks to them. And they go, you know what? Enough is enough, man. Bevo, we demand a formal accounting. You need to produce an accounting that shows us what you did with all the money that came in and all the money that went out. Assume Bevo never responds. Has Bevo violated any duties to his beneficiaries? What can the beneficiaries do if he doesn't say anything? What do you guys think? I've got one answer. Sue to have a new trustee appointed by the court. Any other answers? Connie, I got to tell you, I love you because you got both parts of that. That's pretty much 100%. The beneficiaries are going to say, you know what I can do? I can sue you. Well, I can start a lawsuit and pull a probate court judge into this and have him order you to produce the accounting. The scary part about that is that when you don't follow the orders of a judge, then you find yourself in contempt of court. And the judge can do nasty things to you, but probably the easiest thing for him to do is just sign an order saying, you're not the trustee anymore. And that means the next trustee takes over, and I might award attorney's fees to the beneficiaries who had to pay for an attorney to sue you. The story here, my friends, is you really want to keep beneficiaries in the loop so it never comes to this. You typically want to let them know, hey, here's what I'm doing, here's the plan, let me set some expectations so you never find yourself in this pickle right here. How do you avoid getting into this pickle? How should Bevo discharge his duty to keep the beneficiaries informed? Okay, I confess, I kind of gave it away. He should write a roadmap letter to the beneficiaries. because that creates a paper trail of, hey, I'm the trustee, I'm looking out for you guys, here's what's going to happen. And typically, here's what you want to put in that letter. If you're a beneficiary, you want to know what's in the trust. So that is a fair thing to put in the letter. You want to put in a copy of the trust and the will so the beneficiaries can see, hey, I'm not just arbitrarily making decisions. Here's the sections that I'm using to decide what I'm going to do. I'm not just awarding you guys a third out of the blue. It's what the trust told me to do. You typically want to set expectations on what you're going to do. For example, you might need to be upfront and say, hey, I'm really busy at work right now, and mom left a huge stack of documents to go through. It might take me a few months to get through these things. If you want to help me out, you're free to come over and help me go through these papers. So typically, that's what I want to see in the letter, because that protects you. And it says, hey, I'm doing what I can. Here's what I expect to happen. And I'll keep you updated on what I'm doing. So we're almost to the home stretch, you guys. This is the best part. Finally making distributions to the beneficiaries. But let's cover how we got here. Remember, we had to locate the assets and get custody of them. We paid mom's valid expenses, and we have fulfilled our duty of loyalty and disclosure to our beneficiaries by telling them what's going on. So now it's time to make distributions. That's the best part. So let's go through some examples. How should Bevo distribute the house? Let me help refresh your memory. The trust says I've got 3 kids. I want to distribute my property equally between my kids. How should Bevo distribute the house? What should he do? I've got one answer, sell it. Any other takers? Full disclosure, that's typically my recommendation. That's typically my recommendation, is to sell. But you see, I've got another, perfect. The other comment is the other side of the coin, which is undivided interest so that they're all co-owners. So you guys anticipated the next slide equally. Very good. Typically, you've got 2 situations. My answers in chat, you both anticipated the size of the coin. In one case, everyone agrees to sell the house, right? The kids say, this is mom's house. We all have our own places. We don't intend to live there. We don't want to rent it out. So they'll just say, okay, let's sell the house. In this case, you just hire a realtor, get it sold. Typically, if you sell the house pretty quickly after mother dies, there's no capital gain on the sale, and you just divide the cash. Where it gets thorny is when someone says, I want to keep the house. Somebody says, I want to keep the house. But the other beneficiaries say, I'm not interested. I'm not interested in keeping the house. I just want cash. Typically, at that point, what you got to do is you want to try to get the beneficiaries to come to an agreement on a plan. Ideally, what you do is, in a perfect world, the beneficiary who wants to keep the house can get a loan large enough to buy out the other beneficiaries. So, for example, say if Masked Rider says, I really like this house. I will get a loan that pays out my brothers so that they are indifferent, right? They get the same amount of cash they would have gotten if the house were sold. You typically hire a realtor or an appraisal guy to get you a value for the house. So let's give you a concrete example. say it's a unique ranch, right? It's a unique ranch. It's got a lot of sentimental value. Bevo and Reveille want to sell the house. They just want cash. Masked Rider wants to keep it, but cannot get financing. Remember, he got divorced, so his credit's really bad. So he's not feeling too good right now. The ranch expenses are adding up each month because it's not free to own this ranch. How do we resolve this? What do you guys think?
Second mortgage.
I heard a comment from chat, a second mortgage. Brothers take a note. Owner finance sale. You guys are hitting it. You guys are doing my job for me. That's fantastic. Basically, we've got to find a way to generate cash somehow. So, Masked Rider, if he can't get a loan by himself, he might try to convince his brothers to say, what if you finance it for me? What if I make monthly payments to you guys? And, you know, that's really up to Bevo and Reveille to see how they feel about that. And that's kind of a tough sell if they don't really trust Masked Rider. The real answer to this, and I know this is kind of a tricky question, the real answer to this was that if you were drafting this trust and you knew that this unique ranch had some sentimental value to your kids, you would try to build in a buy-sell agreement already. So the terms of the sale would already be written, and you might buy life insurance on your life so that there's money available to finance the buy-sell agreement. Okay, you guys, I confess, I was not keeping track of time very well at all. We are coming up on 7:30. I'm really glad I got to have you guys tonight. I want to give you guys some time to ask me any questions on what we've covered tonight. And if you need to go, please feel free to go. I don't want to keep you here if you've got other engagements. So I'm just going to open up the floor. Any questions you've got, hit me up in chat or over the voice, and I'd be happy to help. I'm going to flip to the back. So you've got our contact info. If you've got any questions that you'd like just a personal answer to, you've got our email addresses up there. I'm Chris, and our phone number. And please feel free to contact us with any questions you've got. I really love doing these presentations for you guys. I love having you guys here. And, Kathy, I see your comment in chat. Shoot us an email. Shoot us an email so we can give you a specific answer for your case. All right, you guys. I'm going to give you just a little more time. A little more time. Any questions? Fair game. I got a question from Ginger. Can the beneficiary of a trust keep assets in the trust indefinitely? Can they transfer their assets in the same trust for their future beneficiaries? So let me answer the first part first. I don't know if you guys can see Ginger's question in the chat. Can the beneficiary of a trust keep assets in the trust indefinitely? Yes and no. So I think and correct me if I'm misunderstanding your question, Ginger. For Mama, let's say we're talking about Mama Texas. For Mama Texas, the typical rule is that if you've got a trust and you set it up and you run the trust, you can leave the assets in there as long as you want until you die. And then when you die, there's got to be some sort of plan for what happens to those trust assets. In our case, we had to go out to the three kids equally. The second question, I'm not quite clear on, Ginger. And I'm not quite sure I answered your first question. I was trying. Ginger, I think we lost you. Okay. Okay, Ginger, I see your note. I'll send you a message later. That's perfect. Yeah, Connie, you're exactly right. If there's a sole beneficiary and it's your trust, you just run it for as long as you like. Adrian, I see your question. Let me go through it. Adrian, on your question, my gut reaction is to say the statute of limitations has run on that bill. Without seeing the debt statement, I'm going to say it's a typical unsecured claim. And I'm going from memory here. Don't quote me on this, but I think the Texas Property Code says the statute of limitations for normal unsecured debt is 4 years. So I think it's been long enough to, well, they can't sue you for that claim. So I would just let it go. Yeah. And then, all right, Vance, I'm going to give you the last question. Can the trustee leave assets indefinitely? Wait, Vance, what do you mean by indefinitely? Help me out here. Like to someone forever, or make the trust hold the assets forever? Oh, okay. So yeah, if I'm understanding the question correctly, Mama can say, you know what? I don't want Bevo, Master Rider, and Reveille to get all the money at once. I want to spread it out over a number of years. So without getting into typically subject to some pretty easy restrictions, you can typically force the trust to hold on to the assets for the benefit of the beneficiaries over a really long amount of time, say 10, 20, 30 years, if that's necessary. Oftentimes, you'll see that for grandkids. For example, if you're planning for a grandchild and they're only 1, for example, or 2, you typically don't want to give it to them before they're 21 because, or 25, or maybe even 35, because you're concerned that they're not old enough or mature enough to manage it. So in that case, yeah, typically you can say, you know what? I'm not going to give the trust assets to the kids immediately. I can force them to wait some time to go get their assets. I hope that answers the question, Vance. Perfect. You guys, that's going to be it for me. I'm really glad to have had you guys tonight. I really appreciate it. I really appreciate it. Adrian, what we're going to do is we're going to record it, and we can get you the YouTube link once it's posted so you can share it with your siblings. Yeah. Thank you for sharing it. I'm glad that you liked it enough to share it. So you guys, stay warm out there, and I hope you guys have a really great Halloween. My dentist is going to make a lot of money off of me very soon. So I might not be showing you my teeth in the next few weeks. All right, you guys, I'm going to call it a night. I love you guys. I'll see y'all later. Bye, Connie. I see you waving.